My sister Victoria, who everyone called Tori, had summoned me to dinner the night before our federal court hearing. That timing alone told me everything I needed to know about what this evening would actually be about. Nobody invites their estranged sibling to a mansion, dinner the night before a legal battle out of familial affection. They do it because they want something, and whatever that something was, I already knew I wasn't going to give it to her. The north side of Atlanta unfolds differently than the parts I'm used to. Wide roads with landscaped medians, shopping centers with valet parking, churches with campuses that look like small colleges. Everything feels planned, curated, maintained by people whose job it is to make sure nothing looks worn or forgotten. My 10-year-old Toyota Corolla with its dented rear bumper and 175,000 miles didn't belong on these roads, and the glances I got from drivers passing in their luxury SUVs made that clear. I didn't mind. My car had taken me through deployments, across state lines for training exercises, and through more than a few snowstorms that would have stranded something more delicate. It ran reliably and asked for nothing except oil changes and occasional repairs. That's more than I could say for most things in life, including some of the people I was related to. Tori's mansion sat behind iron gates that opened automatically when I pressed the call box button. I suppose she had seen me on the security camera, because there was no greeting, just the slow swing of the gates parting to let me through. The driveway curved through a lawn so green it looked artificial, bordered by trimmed hedges that probably had their own maintenance schedule and budget. Her husband's brand new imported SUV gleamed in the circular drive, parked next to a fountain that probably cost more than my annual salary. I pulled up behind it, and the contrast between my practical, tired sedan and his status symbol was almost theatrical. Almost. I would have found it funny if there weren't so much at stake. The front door opened before I could even raise my hand to knock, and there stood my sister, Victoria, looking like she had just stepped out of a magazine spread about successful women in their 30s. She wore a fitted cream blazer over a silk blouse, tailored pants that probably cost more than my monthly rent, and heels that added 4 inches to her already impressive height. Her hair was styled in that effortless way that actually takes an hour with a professional, and her jewelry caught the evening light in a way that screamed careful curation. When she looked at me, her eyes moved from my boots up to the sleeves of my Army service uniform, and I watched her smile tighten into something that barely qualified as a greeting. "You actually wore that?" The question came out like she was asking if I had really shown up to a formal dinner in a swimsuit. Her eyes lingered on the slightly worn cuffs of my jacket, and I saw her jaw clench the way it always did when she was trying not to say something truly cutting. "Yes," I answered simply. There wasn't any point in explaining that I had come straight from Fort Liberty after a long drive, that I hadn't had time to change into civilian clothes, or that my uniform was clean, pressed, and regulation compliant even if it wasn't new. The cuffs were worn because I had worn this uniform to promotions and memorial services and official briefings for years. Fabric doesn't stay crisp forever, no matter how carefully you maintain it. But that wasn't something Tori would understand. In her world, clothes were statements, branding, signals about status and success. In mine, they were identification. She stepped aside and let me in without another word about my appearance, though her eyes continued to evaluate me as I walked past. The foyer of her mansion smelled like expensive candles and polished wood, the kind of scent that comes from products that cost more per ounce than most people spend on groceries in a week. Everything inside looked staged for a magazine shoot, from the glass table in the center to the marble floors beneath it, to the art on the walls that probably hadn't been chosen for sentimental reasons. There were no fingerprints anywhere, no signs that anyone actually lived here. It felt more like a showcase than a home. Tori walked me into the dining room, where her husband Daniel was already seated at a table long enough to host a small conference. He leaned back in his chair with a glass of scotch in one hand, his tailored suit jacket unbuttoned to reveal a pressed dress shirt and silk tie. Daniel was a corporate litigation attorney at one of Atlanta's most prestigious firms, and he carried himself with the particular confidence of someone who bills by the hour and never loses sleep about whether his clients can afford it. He wore success like it was tailored to him, custom fit and perfectly maintained. When I entered, He looked me up and down the same way Tori had, and his mouth curved into something that wasn't quite a smile. They both looked at my sleeves again, and I watched them exchange a glance that communicated everything they weren't saying out loud. It was Tori who laughed first, a short sound that carried more condescension than humor. "You look like a tired security guard," she said, shaking her head slowly as if she couldn't quite believe what she was seeing. "And you're planning to wear that into federal court tomorrow," Daniel added, his smirk deepening. "Presentation matters." I sat down without reacting. The table was massive, polished to a shine, with place settings that looked like they had been arranged by someone with a ruler and an obsessive attention to symmetry. It could have seated 12 comfortably, but tonight it was just the three of us and a single folder placed in front of Tori's seat. The absence of anyone else felt deliberate, a way of making clear that this wasn't a family gathering. This was a negotiation. Dinner arrived from a private chef I never saw, brought in by staff who materialized just long enough to place plates, and then disappeared without making eye contact. The food was something with rosemary and red wine sauce, expertly prepared and beautifully presented. I focused on my plate because it was easier than focusing on the way Tori was watching me, waiting for an opening. She didn't touch her food. She was too busy studying me like I was a problem that needed solving. "You really think that judge is going to take you seriously looking like that?" she continued, her voice carrying the patient tone of someone explaining something obvious to a child. "This isn't a base legal office. It's federal court." The way she said federal court made it sound like a country club she belonged to, an exclusive space where people like me didn't qualify for membership. I took a sip of water and set the glass down carefully. "The judge will look at the documents." Daniel let out a short laugh, the kind that dismisses without being overtly hostile. "The judge will look at credibility, presentation, whether the person standing in front of them looks like someone who belongs in a position of authority." Tori slid the folder across the glass table toward me. It stopped just short of my plate, and she watched me with the expectant patience of someone who had rehearsed this moment. "Open it." Inside was a cashier's check for $75,000. The amount was written in careful figures, official and precise. I looked at it for a long moment, then looked up at my sister. "For what?" "For being reasonable," she replied. "Sign the waiver. Step down as executor. Let me handle the land. You take the money and go back to North Carolina." Daniel leaned forward, his expression shifting to something that was probably meant to look supportive. "It's more than generous. You don't even own property right now." That part was true. I rented a modest apartment near Fort Liberty because my job moved me around every 2 to 3 years. I didn't invest in luxury real estate because I had learned that stability isn't about owning things. It's about being able to pick up and start over without losing yourself in the process. My car was old but reliable. My savings were modest but consistent. My life was simple but sustainable. That wasn't something Tori had ever understood. "The land isn't for sale," I said quietly. Tori's jaw tightened, and for a moment I saw the frustration break through her carefully composed expression. "It's 200 acres of undeveloped forest. Dad didn't even maintain it properly the last few years. Magnolia Resorts is offering real money, jobs, revenue, growth. That land could be contributing to the economy instead of sitting there doing nothing. Dad put a conservation easement on it." I kept my voice level, factual. "He signed it, filed it, you know that." She waved her hand dismissively. Like I was talking about a parking ticket instead of a legally binding agreement. Easements get challenged all the time. Courts revisit them. Circumstances change. Daniel tapped the table lightly, drawing my attention. "The easement is tied to a federal tax credit. That's the only reason we're in federal court instead of probate. If we remove you as executor, we can revisit the validity of that filing. Challenge the circumstances under which it was executed." There it was, not just a disagreement about what to do with the land. A strategy to dismantle the legal protection Dad had put in place. They weren't just trying to buy my cooperation. They were trying to remove the only person standing between Magnolia Resorts and 200 acres of protected forest. "You think I'm the weak link." "We think you're inexperienced," Tori replied smoothly. You've been in the Army your entire adult life. Logistics, civil affairs, deployments. That's not estate management. That's not fiduciary responsibility for a multi-million-dollar asset. I didn't correct her about my branch or my actual responsibilities. It wasn't necessary. She had already made up her mind about what my service meant, and nothing I said would change that. You live in a rental apartment, she added. You drive that car. You don't have a portfolio. Tomorrow, in front of a federal judge, they're going to ask why you should control a multi-million-dollar asset. What qualifies you? What experience do you have that's relevant? Daniel nodded in agreement. And we're going to answer that question for them. We have financial comparisons, income disparities, asset management experience. We have precedent. You have a government salary and deployment history. I looked at the check again. $75,000. A clean exit. More money than I would see in a year of active duty pay. Enough to make a down payment on a house, upgrade my car, start building the kind of portfolio Tori thought mattered. You're trying to buy Dad's wishes, I said. I'm trying to fix a mistake. Tori's voice sharpened. He was emotional at the end. He didn't understand the market. He signed that easement because he was scared, not because it was the right decision for this family. He understood exactly what he signed. Her expression hardened. You think this is about trees? It's about responsibility, about maximizing value, about making sure this family benefits from what we've been given instead of letting it sit empty because Dad got sentimental in his final years. It's about honoring a document, I said. A document he signed willingly, with full understanding of what it meant. Silence settled over the table. Not dramatic, not theatrical, just quiet. The kind of quiet that happens when two fundamentally different worldviews collide and neither can find common ground. Tori pushed the check closer to me. Last chance. Sign the waiver tonight. We avoid tomorrow's embarrassment. Everyone wins. Whose embarrassment? She looked directly at my sleeves again, at the worn fabric that had so clearly offended her sense of presentation. Ours. Daniel leaned back in his chair, swirling the remaining scotch in his glass. Federal judges don't salute uniforms. They analyze competence. They look at track records and financial statements and evidence of sophisticated decision-making. Tomorrow, we're going to present all of that. What are you going to present? I held his gaze. Good. Tori laughed again, louder this time. You really believe that? You walk in there in that worn-out suit and you think anyone sees leadership. You think anyone looks at you and thinks, yes, this is the person who should be managing a multi-million-dollar estate. I looked down at my uniform, at the ribbons and badges aligned precisely where regulations required them to be. The bronze star ribbon was centered and secure. The combat action badge sat above the ribbons exactly where it belonged. The fabric was worn, yes, but it was clean. It was proper. It represented years of service that had cost me things Tori couldn't begin to understand. I'm not dressing for them, I said. For who then? For myself. She rolled her eyes. You always do this. You go quiet and act like that's strength, like silence is some kind of moral high ground. It works. Daniel cleared his throat, drawing the conversation back to business. Let's be realistic. Tomorrow we're asking the court to remove you as executor. We have financial comparisons, income disparities, asset management experience. You have a government salary and deployment history. In the cold arithmetic of a federal courtroom, which do you think will carry more weight? That's enough, I said. For what? I'm not signing that. She stared at me for a long second, and I watched the calculation behind her eyes shift. You're making this harder than it needs to be. No, I replied. I'm making it exactly what it is. Her expression shifted from mockery to frustration, from condescension to something closer to anger. You're going to regret walking into that courtroom like this, looking like that, presenting yourself as someone who belongs in a position you're clearly not qualified to hold. I closed the folder and pushed it back toward her. I'll see you in the morning. Daniel shook his head slowly. You're walking into a federal hearing underdressed and unprepared. This isn't a military briefing. You can't just follow orders and expect everything to work out. I'll be prepared. Torai stood up, and for a moment I saw the sister I remembered from childhood, the one who had always been better at everything, who had always known exactly what to say and how to say it. Fine, but don't expect us to protect you when this backfires. Don't come to us when the judge sees through this act and realizes you're in over your head. I rose from the table. I'm not asking you to. She glanced once more at my sleeves, at the fabric that had become her obsession. You could at least buy a new suit, show some respect for the process. I adjusted the cuff lightly, feeling the worn edge under my fingers. This one still fits. I walked out through the same marble hallway I had entered, past the polished staircase and the framed awards from Torai's real estate firm. Everything in her house said success, but nothing in it said peace. Outside, the air was cooler, the kind of Georgia evening that hints at autumn even in late summer. My car looked even older under her driveway lights, its dented bumper and faded paint a rebuke to everything her mansion represented. I got in, started the engine, and let it idle for a moment. Tomorrow wasn't about fabric. It wasn't about presentation or credibility or whatever narrative Daniel had constructed to justify what they were trying to do. It was about a document filed years ago, a signature placed carefully at the bottom of a conservation easement, and a federal court that would decide whether that signature meant anything. Behind me, inside the mansion, they were probably finishing dessert and planning how to dismantle me in the morning. They had resources I didn't have, connections I didn't have, a lifetime of experience navigating the world they had built for themselves. But I had something they didn't. I had a document that said exactly what Dad wanted, signed by his own hand, witnessed and notarized and filed with the county. And I had spent my entire adult life learning how to hold a line when people tried to make me move. I shifted the car into reverse and drove out through the iron gates without looking back. The highway lights blurred past my windshield as I drove north, the mansion shrinking behind me in the rearview mirror until it disappeared entirely. Traffic thinned out once I left the city proper, Atlanta's sprawl giving way to darker roads and fewer billboards. The transition was almost physical, like shedding a skin that had never fit properly. My sister's world, with its polished surfaces and calculated interactions, always left me feeling like I had been holding my breath without realizing it. Only when I was back on the open road could I finally exhale. I had planned to drive straight to my hotel near the federal courthouse, but somewhere around exit 137, I turned off the highway instead. The land sits about 90 minutes outside the city, past the last chain grocery store and a handful of gas stations that close early. 200 acres of mixed hardwood forest, rolling hills, and a narrow creek that runs along the eastern edge. No gate, no security camera, just an old gravel entrance and a wooden sign with our family name carved into it. Callahan Property. Dad had carved that sign himself after he retired from the Marines. He said if he was going to own land, he wanted to touch it first. Every letter cut by hand, every edge sanded smooth. The whole thing treated with sealant, he applied himself on a hot July afternoon while I held the board steady. That sign had weathered 15 years of Georgia seasons, and it still looked more real than anything in Torai's mansion. I turned onto the gravel road and let the tires crunch slowly forward. The trees closed in overhead, blocking out what little light remained in the sky. Even at night, you can tell the difference between a developed property and one that's been left alone. No light pollution, no paved driveways, no carefully arranged landscaping. Just trees and undergrowth and the sound of wind moving through leaves. I parked near the old shed and stepped out. The air smelled like damp soil and pine, nothing manicured, nothing staged. The kind of smell you can't buy in a candle or recreate in an air freshener. It was the smell of a place that existed on its own terms, that didn't need anyone's approval or investment to be what it was. Torai calls it underutilized. I call it intact. The conservation easement wasn't some last-minute emotional decision Dad made when he was sick and scared, the way Torai liked to frame it. He had been talking about it for years, long before his health started declining. After his second heart scare, the one that landed him in the hospital for a week and left him needing a walker for months. He started meeting with a land trust organization out of North Georgia. They walked the property together, documented wildlife, surveyed boundaries, filed everything properly. The easement restricted development permanently. No subdivision, no resort, no commercial construction of any kind. The land would remain as it was, in perpetuity, protected by a legal framework that was designed to survive changing circumstances and changing minds. It qualified for a federal tax deduction under IRS Section 170H. That deduction was the reason this case had landed in federal court instead of staying in probate where estate disputes usually lived. Dad had claimed the deduction, the IRS had accepted the filing, and now Tori and Daniel were trying to undo the whole thing by attacking the person Dad had chosen to protect it. I walked down toward the creek with a flashlight, the ground uneven beneath my boots but familiar. I used to spend summers here before ROTC, before deployments, before the Army turned my schedule into a series of departure dates and return windows. This was where I learned to shoot, where Dad taught me to track deer and identify trees and navigate without a compass. This was where he came to think, he said, because the land didn't require anything from him except presence. Dad used to say the land was the only thing in his life that didn't require rank or permission. In the Marines, everything was structured. Everything had rules and chains of command and procedures that had to be followed. But out here, he was just a man walking through trees. No one saluting him, no one expecting him to make decisions that would affect people's lives. Just quiet and wind and the sound of the creek moving over rocks. I sat on a fallen log near the water and pulled out my phone. I opened the email thread I had printed earlier that week, the one I had found in Dad's files after he passed. Subject line, Magnolia Resorts, Preliminary Development Proposal. It was addressed to Tori, dated 6 weeks before Dad died. The attachment contained projected revenue numbers, design mock-ups showing luxury cabins and an elevated lodge, and a draft letter of intent outlining the terms of a potential sale. The numbers were impressive, I had to admit. Millions of dollars in projected revenue over the first decade. Hundreds of jobs for the local community. A high-end destination that would put this corner of Georgia on the map for wealthy tourists. But that wasn't what made my stomach clench. In one message, buried in a thread between Tori and the Magnolia Development Director, she had written, "Once the estate is settled, we'll clear the easement issue. My brother is reasonable. He'll see the financial logic." Clear the easement issue. Like it was brush in the way of a driveway. Like Dad's signature on a legal document was just an obstacle to be removed rather than a decision to be respected. I wasn't surprised she wanted to develop the land. That's what she did. She looked at empty space and saw potential profit, vertical growth, investors, market timing, appreciation curves. She had built her career on finding undervalued properties and turning them into revenue generators. That was her skill, her passion, her identity. Dad had always known that about her. But Dad looked at this land and saw quiet. He saw a place that didn't need to be improved or monetized or transformed. He saw something worth protecting precisely because it wasn't generating profit. When he told us he was nomming me executor, Tori hadn't argued in front of him. She waited until we were alone in the kitchen, after he had gone to rest, before she asked the question that had clearly been burning inside her. Why her? He didn't hesitate, because she won't sell it. At the time, I thought that was enough explanation. Apparently it wasn't. The executor role isn't glamorous. It's paperwork, court filings, inventory of assets, making sure debts are paid and directives are followed. It's not about profit. It's about compliance. Tori sees compliance as a starting point for negotiation, a baseline from which you can argue for better terms. I see it as the entire point. The will says what it says. The easement says what it says. The job is to make sure those documents are honored, not reinterpreted. I walked back toward the shed and leaned against the wooden wall. The flashlight beam caught the edge of an easement marker posted near the boundary line, a small metal sign indicating protected land. It was one of several Dad had installed after the filing was complete. Magnolia Resorts would have bulldozed this entire stretch first. It's the flattest area on the property, the easiest to develop. The The creek would have been rerouted or filled in. The trees would have been cleared for construction. All of it transformed into something profitable and unrecognizable. The federal element complicated everything. Because Dad had claimed a conservation tax deduction when he filed the easement, the IRS had jurisdiction over the legitimacy of that filing. Challenging the easement meant challenging a federal tax matter. That was why Daniel had filed in U.S. District Court for the Northern District of Georgia instead of keeping this in probate court where it belonged. He wasn't just attacking my role as executor. He was trying to reopen the validity of a federal filing. If the court ruled the easement defective, it could trigger tax penalties against the estate. It could reclassify the land as unrestricted, opening the door to the development Torai had already been negotiating. Removing me as executor was step one. Without me, Torai could petition to renegotiate the land trust agreement, claiming changed circumstances or new information that warranted revision. I checked my phone again. A message from my unit's security manager sat unread. Reminder: disclose ongoing federal litigation in clearance file. I had already reported it earlier that week, as required. Army officers with active security clearances are required to disclose significant civil litigation. It doesn't mean you're guilty of anything. It just means the government wants transparency about anything that could affect your reliability or make you vulnerable to coercion. Still, it's not ideal. If Daniel succeeded in framing me as financially incompetent in federal court, that narrative wouldn't disappear when I put the uniform back on. Security clearances are renewed periodically, and anything that raises questions about judgment or reliability gets scrutinized. Torai had built her strategy carefully. She knew my career required credibility. She knew public questioning of my judgment could ripple outward in ways that extended far beyond this estate. I turned off the flashlight and stood in the dark for a minute. No traffic noise, no legal arguments, just wind moving through trees and the distant sound of the creek. When Dad filed the easement paperwork, he had brought me the draft before signing it. "Read it," he said. I did, every line. Legal descriptions, boundary maps, restrictions, duration, perpetual. I asked questions about enforcement, about what happened if circumstances changed, about whether the restrictions could be revisited if the family needed money. "You understand what this means?" he asked when I finished. "It means no one can touch it." "That's the point." He wasn't naive. He knew the land was valuable. He knew Torai's industry and what she would want to do with it. He wasn't against development in general. He was against turning this specific place into a revenue stream. Against treating it as an asset to be optimized rather than a promise to be kept. He told me something else that day, standing in this same spot where I now stood alone. "If this ever becomes a fight," he said, "don't argue with emotion, argue with paperwork." I looked around at the trees, then back at the shed where we had kept tools and camping equipment and the history of our family's relationship with this land. Paperwork was exactly what we had. Dad had been meticulous. The easement had been reviewed by a certified appraiser approved by a 501(c)(3) land trust and recorded with the county. The IRS deduction was processed without issue. There was nothing sloppy about it, nothing that suggested he was confused or pressured or not of sound mind when he signed. The attack wasn't on the document, it was on me. Daniel's motion to remove me as executor cited lack of financial sophistication and limited asset management experience. He attached my military income statements as comparison against Torai's corporate earnings. Income disparity as a legal argument for incompetence. It was clever, in its way. He wasn't claiming I had done anything wrong. He was claiming I wasn't the right person for the job, that the estate deserved someone with better credentials and more relevant experience. I walked back to my car and sat behind the wheel without starting it. The dashboard clock read 11:42 p.m. Tomorrow they would stand in a federal courtroom and present me as underqualified. They would point to my rented apartment and my government salary and my lack of investment portfolio. They would use words like competence and sophistication and capacity, like they belonged exclusively to people who worked in boardrooms and billed by the hour. I rested my hands on the steering wheel and looked through the windshield at the dark outline of the trees. Dad didn't choose me because I was richer or more successful or better at making money. He chose me because I follow instructions, because I understand that some decisions aren't meant to be revisited every time circumstances change, because he knew I would hold the line when someone tried to make me move. The instructions were clear. I started the engine and let the headlights cut through the gravel road, guiding me back toward the highway. The gravel faded into pavement as I merged onto the main road, and the headlights stretched in a straight line toward Atlanta and whatever the morning would bring. By the time I reached my hotel near the federal courthouse, it was after midnight. The hotel was nothing fancy. Clean bed, neutral carpet, the kind of place where no one asks questions if you're in uniform. I had stayed here before when I had business in the city, and I chose it for the same reason I chose most things. It was practical, affordable, and reliable. I laid the court binder out on the desk and opened it again. Daniel's motion to remove me as executor was neatly structured, confident, professional. He had written it the way he probably wrote everything, with precision and strategic intent. He framed the issue as a matter of fiduciary responsibility, not sibling rivalry. That was deliberate. Federal judges don't care about family dynamics. They care about legal standards and statutory requirements. He argued three things. First, that I lacked sufficient financial experience to manage a multi-million-dollar estate. Second, that my full-time military obligations created a conflict with executor duties. Third, that maintaining the conservation easement without reevaluation could materially diminish asset potential. Asset potential. That phrase appeared 6 times in the filing. It was the core of his argument. The estate was worth more if developed, and I was preventing that value from being realized. He attached financial exhibits comparing my annual Army pay to Torai's corporate earnings. The contrast was stark. She made in 6 months what I made in 2 years. He included market projections from Magnolia Resorts showing projected revenue over 10 years if the land were developed. The numbers were impressive, I had to admit. On paper, it looked persuasive. Why would anyone choose to leave money on the table? What he did not mention was that an executor's job is not to maximize profit. It is to execute the will as written, to carry out the wishes of the deceased regardless of whether those wishes align with what would be most profitable. That's the entire point of a will. It reflects what someone wanted, not what would have been most advantageous. I turned to the copy of the easement agreement. Signed, notarized, recorded. The land trust's acceptance letter was attached. IRS Form 8283 was properly filed at the time the deduction was claimed. The appraisal met federal standards. Everything was in order. So the strategy shifted. If they couldn't attack the document directly, they would attack the person enforcing it. I closed the binder and checked my phone again. A secure email from my unit's security office confirmed my litigation disclosure had been received and logged. No further action required at this time. Those last 4 words mattered. No further action. They meant the security office didn't see this as a red flag, at least not yet. But if Daniel succeeded in framing me as incompetent in federal court, that assessment could change. Still, federal court is not something most Army officers casually add to their week. Civil affairs officers work with local governments, community leaders, infrastructure projects. We operate in environments where documentation and compliance are critical, where following procedures can mean the difference between success and failure. That part of my job aligned cleanly with executor duties. But Daniel wasn't going to argue nuance. He was going to argue optics. He was going to show the judge a picture of 2 sisters, one successful and sophisticated, the other wearing a worn uniform and driving a beat-up car, and ask which one should be trusted with a multi-million-dollar asset. The next morning, I walked across the street to the courthouse to familiarize myself with the building layout. U.S. District Court for the Northern District of Georgia sits in a granite structure that looks exactly like what you imagine when someone says federal. Wide steps, tall columns, security checkpoint inside. The kind of building that was designed to look permanent, like the institutions it houses. I cleared security without issue. Active duty ID simplifies things. The officer at the metal detector glanced at my uniform and waved me through without asking me to remove my belt or empty my pockets beyond the standard requirements. Inside, everything was orderly. Courtroom assignments posted on a digital screen. Attorneys in dark suits walking purposefully down hallways. The particular hush of a place where serious matters are decided. Our hearing was scheduled in courtroom 4B at 9:00 a.m. I located the room and stepped inside. Empty benches, counsel tables, the judge's bench elevated but not theatrical. This wasn't a movie set. It was a workplace. I sat briefly at the defendant's table, getting a feel for the space. Tomorrow, Daniel would sit across from me, likely with an associate or two. Tori would be behind him, observing, evaluating, probably already planning what she would do when she won. The hearing was procedural. Daniel was asking the court to remove me as executor and to authorize review of the conservation easement under federal tax implications. If he succeeded in the first request, the second would become easier. Executor removal requires proof of mismanagement, conflict of interest, or incapacity. There was no mismanagement. All estate filings were current. Debts paid. Asset inventory complete. So the argument rested on capacity. Capacity can be subjective. After leaving the courtroom, I stepped outside and called Colonel Harris, my brigade commander. He had been briefed on the litigation when I disclosed it earlier that week. "You good?" he asked. "I'm good." "You expect this to affect duty performance?" "No." "Then treat it like any other administrative issue. Facts win." Facts win. Simple. He didn't ask what I was wearing. He didn't advise me to soften anything or present myself differently. In the Army, your record speaks. It's documented, structured, verifiable. Civilian courtrooms work the same way, even if the presentation style differs. I returned to the hotel and reviewed Daniel's supplemental memorandum. He cited case law regarding fiduciary competence. In one precedent, an executor was removed due to failure to properly manage investments. In another, removal occurred because of prolonged absence from the jurisdiction. He subtly implied that my deployments demonstrated a pattern of absence that made me unreliable. My Afghanistan deployment had ended in 2015. I had been stateside for years. He knew that. But the suggestion alone could plant doubt, could make a judge wonder whether military service really was compatible with estate management. I drafted a response outline for my counsel. I wasn't representing myself entirely. Estate matters require formal counsel of record, and I had retained Ms. Parker, an attorney experienced in probate and federal procedural overlap. She had already prepared counterarguments emphasizing that executor removal cannot be based solely on income level or career path. Still, I wanted my own notes, not emotional arguments, structural ones. Executor duties completed to date. No breach of fiduciary obligation. No delay in asset distribution. No personal benefit taken. Compliance with land trust requirements. IRS documentation intact. I paused and looked at the uniform jacket hanging on the back of the chair. Tori had called it worn out. Technically, it was older. I'd worn it to promotions, memorial services, official briefings. Fabric doesn't stay crisp forever, but it was regulation compliant, clean, proper. Daniel had made a comment the night before that stayed with me. Federal judges don't salute uniforms. He was right about one thing. Judges don't rule based on fabric. They rule on filings. The easement filing was solid. The executor documentation was clean. The financial comparison argument might appeal to emotion, but it didn't override statutory obligations. I checked the docket one more time online. No new filings, no emergency motions. Hearing time confirmed. Downstairs in the hotel lobby, a small television was running a news segment about commercial development in North Georgia. I caught the word resort and muted it in my head. Magnolia Resorts had political connections. They had investors waiting. That pressure wasn't in the courtroom record, but it existed. Tori wasn't just fighting for profit. She was protecting a deal already in motion. If the court removed me, she could move quickly. I went back upstairs, set an alarm for 6:00 a.m., and placed the binder neatly beside my bag. There was nothing left to prepare beyond what was already documented. No last-minute maneuver, no surprise filing, just a federal hearing scheduled for the morning where competence would be measured against compliance and income charts would be weighed against a signed easement. I turned off the lights and let the room settle into quiet. Tomorrow would not be about who spoke louder. It would be about whose paperwork held. The hotel alarm went off at 6:00 a.m., but I was already awake, staring at the ceiling and thinking about a kitchen table from 20 years ago. Back then, our house in Savannah was smaller. One story, yellow siding that Mom had insisted on because she said it looked cheerful. Dad kept his Marine Corps photos in the hallway next to the thermostat, a reminder of where he had been before he came home to teach high school history. Tori kept her academic trophies on the living room shelf, a collection that grew every year. Spelling bees, debate competitions, student council awards. She was always ahead. Student council president by sophomore year, internship at a real estate firm by junior year, acceptance to an elite business program before most of us had figured out what we wanted to major in. When she talked about business, adults leaned in. They asked questions. They took notes. When I talked about ROTC, they nodded politely and asked if I had a backup plan. At family gatherings, relatives asked Tori about internships in Atlanta, about networking, about her trajectory toward something impressive. They asked me if the Army was dangerous, like it was a hobby I had picked up without thinking, like it was a phase I would grow out of once I realized what I was signing up for. Dad never treated it that way. He didn't overpraise me either. He just asked practical questions. Where are you stationed next? What's your chain of command look like? You squared away. The same questions he would have asked any Marine under his command, stripped of sentiment but full of respect. Tori once joked at Thanksgiving that I joined the Army because I didn't like interviews. You don't have to impress a hearing committee, she said. They just issue you a uniform. I remember answering without looking up from my plate. You still have to qualify. She laughed. Everyone else did too. It wasn't cruel. Not exactly. It was the kind of comment that sounds harmless until it repeats for years, until it becomes part of the background noise of every family interaction. By the time I commissioned as a second lieutenant, Tori was already climbing the ladder at her real estate firm. She didn't come to my ceremony. She had a client meeting. She sent flowers instead. The card said, "Proud of you. Stay safe." It was the kind of message that could have been sent to anyone. Dad came. He stood in the back of the auditorium in a pressed shirt and watched them pin the bars on my shoulders. He didn't clap loudly. He just nodded once, the same nod he gave when I completed a training exercise or qualified on a new weapons system. After the ceremony, he shook my hand instead of hugging me. "Now you answer to something bigger," he said. Tori answers to markets. I answer to orders. The difference shaped everything. When Dad bought the land in North Georgia, Tori treated it like a future development site. She asked about zoning restrictions before she asked about trees. She calculated acreage and access roads and proximity to population centers. I asked about water access and boundary lines and what the soil looked like. She'd walk the property and talk about cabins and lodges and profit margins. I'd walk it and talk about maintenance and access and what Dad wanted the land to be. The conservation, easement conversation didn't start as a fight. It started as a disagreement over philosophy. Dad called us both to the dining room table one afternoon years before his death. He laid out a folder with documents from the land trust, everything prepared and ready for signatures. "This locks it in," he said. Tori skimmed the first page and frowned. "Permanently." "Yes." "That's irresponsible." "It's intentional." She looked at me. "You agree with this?" "Yes." "Of course you do." She muttered it like an accusation, like my agreement was proof that I didn't understand what was at stake. The argument didn't escalate that day. Dad was firm, and Tori knew better than to push back too hard in front of him, but she didn't accept it either. I could see the calculation behind her eyes, the way she was already thinking about how to revisit this later, how to find a way around whatever Dad was putting in place. After his second heart scare, when doctors started using words like lifestyle adjustments and reduced stress, Tori's tone changed. She became more strategic, more focused on what would happen after Dad was gone. "You need to think about estate liquidity," she told him during one of her visits. 200 acres tied up in forest isn't strategic. It's not generating any return. Dad leaned back in his chair. Not everything has to be strategic. When he named me executor, he didn't frame it as a competition or a judgment on Torai's character. "It's administrative," he said. "You're structured." That word bothered Torai more than any other. Structured. She built her identity on being dynamic, adaptable, aggressive in negotiation. Structured sounded small to her, limited, bureaucratic. But in the army, structured keeps people alive. It keeps operations within parameters. It keeps documentation clean and chains of command clear and objectives achievable. She once told me I was too quiet to lead. "You don't push back," she said. "You just sit there." "I don't react to everything." She shook her head. "That's not leadership, that's avoidance." In her world, leadership meant dominating a room, controlling the narrative, making sure everyone knew who was in charge. In mine, it meant controlling variables, anticipating problems, making decisions that wouldn't fall apart under pressure. The tension never exploded. It layered. At Christmas dinners, she'd update everyone on acquisitions and closings and market trends. I'd update them on assignments and training exercises and deployment rotations. Her stories came with numbers and headlines. Mine came with acronyms most of them didn't understand. She talked about growth. I talked about readiness. Daniel entered the picture during one of those Christmases. Sharp suit, confident handshake, the kind of smile that says he's already calculated your value. He asked about my branch like it was a trivia question. "So what exactly does civil affairs do?" "We coordinate with local governments and civilian populations during operations." He nodded slowly. "So like public relations for the military?" "Not exactly." He smiled in a way that said he didn't care enough to understand the difference. "Anyway, Torai tells me you're stationed in North Carolina now. That must be nice. Close to family." The distance between our lives widened over time. She moved into a gated neighborhood with security patrols and community pools. I moved from base housing to rental apartments near duty stations, always temporary, always ready for the next set of orders. She bought investment properties. I bought durable luggage. She built a portfolio. I built a record of service. Dad never compared us directly, but others did. "You must be so proud of Torai," relatives would say, their tone implying that my path was what happened when you didn't have the ambition for something better. "I'm proud of both," he'd answer. After he died, that balance disappeared. At the will reading, Torai didn't react when she heard I was executor. She kept her face composed, professional. But when the conservation easement clause was read aloud, when the attorney explained that the land was permanently protected from development, she leaned back slightly. "That's restrictive," she said flatly. "It's binding," the attorney corrected. The difference between those two words defined everything. Restrictive implies limitation, something that holds you back. Binding implies obligation, something you're required to honor. Torai sees limitation as a problem to solve. I see obligation as something to fulfill. When Magnolia Resorts entered the picture, the rivalry sharpened. It wasn't just philosophical anymore. It was financial. Real money was on the table, and that changed the stakes. She brought a glossy proposal packet to one of our early estate meetings. Renderings of a luxury lodge, elevated walkways, a spa overlooking the creek. Guest cabins scattered through the trees in a way that was meant to look natural, but would require clearing half the undergrowth. A conference center for corporate retreats. A restaurant featuring local ingredients. It would honor the land, she insisted. We're not talking about paving it over. We're talking about sharing it with people who would appreciate it. By removing half of it, I replied. She accused me of being sentimental. I accused her of being impatient. Neither of us raised our voices. We didn't need to. By the time she filed the motion to remove me as executor, the quiet rivalry had become formalized in legal language. Reading her declaration in the court filing felt different than hearing her across a dinner table. Executive lacks financial sophistication. Executive's career obligations interfere with estate management. That wasn't sibling commentary. That was sworn language, submitted to a federal court, part of a permanent record. I understood then that this wasn't about convincing her. It was about countering a narrative she had built carefully over years. The golden child versus the quiet officer. The market strategist versus the structured executor. The sister who understood value versus the sister who only understood rules. As I buttoned my uniform jacket that morning, I thought about the words she used most often to describe me, usually indirectly, usually through implication. Small. She never said it directly, but it lingered behind every joke about my car, every comment about my apartment, every laugh about my government salary. Small compared to her world. Limited. Unambitious. The uniform didn't make me bigger. It just reminded me that scale is relative. In her circles, value is measured in square footage and quarterly returns. In mine, it's measured in compliance, trust, and whether people can rely on you under pressure. I adjusted the collar once, checked the ribbons for alignment, and headed downstairs toward the lobby where the early morning coffee smelled stronger than it tasted. The coffee in the hotel lobby tasted burnt, but it did the job. I stood near the window with the paper cup in my hand and watched early commuters cross the street toward the courthouse. Suits, briefcases, phones already pressed to ears. No one looked like they were heading into a family dispute. They looked like they were going to work. For Daniel, this was work. For Torai, it was leverage. For me, it was compliance. At 7:30 a.m., my phone buzzed with a message from Ms. Parker. Daniel filed a supplemental brief at 6:45. Minor additions, nothing dramatic, just wanted you to be aware. I walked back upstairs, set the coffee down, and opened the court's electronic filing system. The supplemental brief focused on executor suitability. Daniel had added a short section arguing that the role required advanced financial literacy, asset optimization experience, and proactive wealth strategy. Asset optimization, that phrase again. He cited Torai's credentials, MBA from a top program, 15 years in commercial real estate development, board memberships, public-private partnerships, a career built on identifying undervalued assets and transforming them into revenue generators. Then he listed mine: Captain, U.S. Army, Civil Affairs Officer, deployment history. He didn't criticize the military directly. That would have looked disrespectful, might have alienated the judge. Instead, he framed it as unrelated experience. While honorable military service does not equate to financial stewardship of a multi-million-dollar estate asset. That was careful language. He wasn't attacking my integrity or my service. He was questioning my relevance. He was saying that the skills I had developed over 15 years of active duty simply didn't apply to the task at hand. Ms. Parker called a few minutes later. They're leaning heavily on comparative earnings, she said, and market opportunity cost. Meaning, they'll argue the land's highest and best use is development. They'll say you're ignoring fiduciary duty by refusing to consider offers. Fiduciary duty is to the will. Correct, but they'll argue you're interpreting the will too narrowly, that you're prioritizing restriction over growth. That's the thing about legal arguments. They don't have to be dishonest. They just have to be persuasive. Daniel wasn't claiming I had stolen money or misfiled documents. He was claiming I lacked vision, that I was so focused on following rules that I couldn't see opportunities. Vision sounds good in a courtroom, Ms. Parker continued. Judges like to think they're protecting assets for future value. Daniel will frame your compliance as rigidity. He also suggested my duty schedule might prevent adequate estate oversight. I know, we've documented your availability and compliance. The estate filings are current. You've missed no deadlines. She paused briefly. You're going to hear them emphasize lifestyle differences, income disparity, career trajectory. They'll paint a picture of two sisters, one successful and one struggling. I've heard it before. I figured. After we hung up, I looked at the binder again. Torai's declaration included a paragraph that stood out. Executive has limited exposure to complex financial instruments and large-scale asset management structures. Limited exposure. It sounded clinical, detached, as if I were a case study rather than a person. In reality, I've managed multi-million-dollar reconstruction budgets overseas, coordinated infrastructure funding with local councils, balanced operational needs with civilian impact. I've negotiated agreements with village elders and provincial governors and international aid organizations. But those line items don't show up on personal tax returns. Civil affairs work doesn't translate neatly into stock portfolios. Daniel's strategy was smart. He understood judges don't like emotional disputes, so he stripped the emotion out of it. He positioned Torai as the pragmatic steward of value, the one who could see what the land could become. He positioned me as the inflexible enforcer of sentiment, the one who could only see what it had been. He would argue that Dad signed the easement in a moment of declining health and limited foresight, that economic realities had shifted since the filing, that revisiting the restriction was responsible governance, not betrayal. He would not use the word greed. He would use the word growth. I buttoned my jacket and checked the time. In a federal courtroom, removal of an executor requires proof of unsuitability. Unsuitability can be based on conflict of interest, incapacity, misconduct, or inability to fulfill duties. I had no misconduct, no incapacity, no conflicts, so they aimed at ability. Ability is subjective. Income comparisons were their anchor. Torai earned more than I did, substantially more. Her financial statements showed diversified investments, property holdings, corporate equity, the kind of portfolio that demonstrates financial sophistication. My leave and earnings statement showed steady government pay. Consistent but unremarkable. On paper, it looked like disparity. In practice, executor competence is about organization, documentation, and adherence to directives. The question isn't who has more money. The question is who can be trusted to follow instructions. Daniel's brief included a line that almost made me smile. Executive's minimalist lifestyle reflects limited engagement with sophisticated financial environments. Minimalist lifestyle. That's one way to describe renting an apartment near base because you might PCS in 2 years. That's one way to describe choosing reliability over status, savings over consumption, readiness over accumulation. I wasn't embarrassed by it, but I understood the optics. In a room full of polished attorneys and financial exhibits, they would contrast that lifestyle with Torai's portfolio. The implication would hang in the air. Who looks more capable? Who belongs in a position of authority? At 8:15 a.m., I stepped outside and walked toward the courthouse. The air was cool, the sky clear, the kind of autumn morning that makes you glad to be alive. Torai and Daniel stood near the entrance, speaking with another attorney I didn't recognize. She wore a tailored navy suit that probably cost more than my monthly base pay. Daniel's charcoal suit fit perfectly, accessorized with a silk tie and expensive watch. They looked like they belonged here. They looked like they owned the place. They noticed me before I reached the steps. Torai's eyes moved over my uniform again, slower this time, cataloging every detail. Daniel offered a thin smile. "Morning, Captain." "Morning." Torai tilted her head slightly, still going with that. "Yes." She glanced toward the courthouse doors. "You understand this isn't personal." "It's filed in federal court," I said. "It's personal." She exhaled softly, as if I were being difficult. "We're trying to prevent long-term financial damage to the estate. That's not an attack." "It is when you question my competence." Daniel interjected smoothly. "It's not about competence, it's about comparative expertise. Different words, same meaning." I looked at both of them for a moment. "You're not arguing the easement is invalid. You're arguing I shouldn't be the one enforcing it." Daniel nodded slightly. "We're arguing the estate deserves the strongest possible management. Your sister has the experience, the credentials, the track record. It's not a criticism of your service. It's an acknowledgement of different qualifications." Strongest. The word hung there, loaded with implication. Torai folded her arms. "You don't have to take this as an insult." "I don't." She seemed surprised by that, like she had expected me to defend myself, to argue, to show the emotion she always accused me of suppressing. "You're walking into a courtroom where numbers matter," she said. "Track records matter. Presentation matters. You think that uniform is going to protect you from questions about whether you're qualified for this role." "They do matter," I agreed, "which is why I'm wearing it." Daniel checked his watch. "We should head in." As they turned toward the entrance, I noticed something in Torai's expression. It wasn't anger. It wasn't mockery. It was certainty. She believed the argument was solid. She believed the judge would see what she saw: income charts, business acumen, market potential, the clear superiority of her qualifications. She believed the court would prioritize expansion over restriction, growth over preservation. Inside the courthouse lobby, the security line moved quickly. Metal detectors, ID checks, routine. We stepped into the elevator together without speaking. The silence was not awkward. It was calculated. Everyone was preparing for what came next. On the 4th floor, the doors opened, and we walked toward courtroom 4B through the narrow window in the courtroom door. I could see a few early arrivals already seated. Legal pads open, briefcases at their feet. Daniel adjusted his tie. Torai smoothed the front of her jacket. I checked the alignment of my ribbons one last time and reached for the door handle. The courtroom door felt heavier than it looked, and for a second I saw my reflection in the narrow glass. Uniform straight, posture steady, no hesitation. Whatever happened next, I was walking in as myself. Not dressed up to impress anyone. Not hiding behind someone else's definition of success. Just me and the paperwork and the truth of what Dad wanted. We stepped inside. Courtroom 4B wasn't dramatic. No theatrical lighting, no movie set ambience, just polished wood, federal seals, and rows of benches that filled quickly when money was involved. A few observers were already seated. Local attorneys between hearings, 2 reporters I recognized from Atlanta business coverage, and what looked like a representative from the land trust, there to monitor the outcome of a case that could affect conservation properties across the state. Daniel set his briefcase down at the plaintiff's table with the practiced ease of someone who had done this hundreds of times. Torai took the seat behind him, positioning herself where she could observe everything without being directly involved in the argument. I moved to the defense table beside Ms. Parker. "You good?" she asked quietly. "Yes." She glanced at my uniform once, not critically, just observant. "They'll push the financial comparison hard. Be ready for it." "I expect that." We organized the documents without rushing. No frantic whispering, no last-minute edits. Everything had been filed. Everything had been reviewed. The evidence was what it was. Across the aisle, Daniel leaned in toward Torai and murmured something. She nodded, then looked at me again. Her expression had changed since the mansion, less mocking, more analytical. She wasn't trying to embarrass me anymore. She was trying to win. The bailiff entered first, then the clerk. Routine movements. Papers shuffled, microphones adjusted, recording equipment activated. At 9:00 a.m., the side door opened. "All rise." We stood. Judge Harold Whitmore entered without flair. Mid-60s, direct posture, the kind of presence that doesn't need to be announced twice. He had been appointed to the federal bench after a distinguished career in private practice and had a reputation for being thorough, fair, and impatient with theatrical arguments. He took his seat and looked out over the courtroom with the calm assessment of someone who had seen everything and was rarely surprised. "Be seated." The hearing began with formalities. Case number, parties identified, counsel of record confirmed. Daniel stood first. He moved smoothly into his argument voice, controlled, confident without being aggressive. "Your Honor, we are requesting removal of the current executor due to demonstrable lack of financial sophistication necessary to manage a complex estate asset valued in the multi-million-dollar range. The conservation easement currently encumbering the property prevents the estate from realizing its full market potential, and the executor has demonstrated unwillingness to consider legitimate opportunities for value enhancement. No mention of sibling tension, No mention of family history. He framed it as risk mitigation, as protecting the estate from someone who couldn't see past the restrictions to the opportunities beneath. He presented charts showing projected revenue under the Magnolia Resort's proposal. He emphasized opportunity cost, the money the estate was losing every year the land remained undeveloped. He cited fiduciary duty case, law suggesting that an executor must consider maximizing value where possible. Executors' refusal to evaluate development proposals reflects rigidity rather than stewardship, he said. In our filing, we have documented the substantial disparity in financial experience and asset management capability between the current executor and the alternative candidate, Ms. Victoria Callahan. He used the word rigidity carefully. It wasn't incompetence, it was inflexibility, a subtle distinction but an important one. Then he referenced my career. While Captain Callahan's military service is commendable, her full-time obligations and limited exposure to high-level financial management create a practical limitation. The estate deserves more than honorable intentions. It requires sophisticated oversight. Practical limitation. He didn't look at me when he said it. He looked at the judge. Torre watched without blinking. Daniel concluded by requesting temporary suspension of my executor authority, pending further review of the easement's federal tax implications. If he could get me removed, even temporarily, the door would open for reconsideration of the development proposal. Ms. Parker stood next. She kept her tone direct, professional, unswerving. Your Honor, executor removal requires evidence of misconduct, incapacity, or failure to fulfill duties. None exist here. The estate filings are current. Debts have been paid. Asset inventory is complete. No missed deadlines, no financial discrepancies, no conflicts of interest. She walked through the compliance timeline, each document accounted for, each requirement met. The will is clear, she continued. The conservation easement was executed and recorded properly, with full understanding of its implications. The executor's role is to implement the will, not renegotiate it based on changed market conditions. The judge listened without interruption, his expression revealing nothing. Ms. Parker addressed the financial disparity argument directly. Income level is not statutory grounds for removal, nor is professional background, absent evidence of mismanagement. The deceased's wishes were explicit. The executor is honoring those wishes. That is not rigidity, that is fidelity. She sat down. The judge leaned back slightly and began reviewing the binder in front of him. The room went quiet, not dramatic, just focused, everyone waiting to see which direction the questions would go. He turned a page, then another. Daniel shifted slightly in his chair. Torre crossed her legs, then uncrossed them. The judge spoke. Counselor, your argument hinges largely on comparative financial experience. Yes, Your Honor. Do you allege mismanagement? No, Your Honor. Do you allege breach of fiduciary duty? No, Your Honor. Then your position is that the executor's professional background is insufficient as a matter of capacity. Yes, Your Honor. The estate involves complex valuation issues and significant tax implications. We believe it requires expertise beyond military logistics. The judge nodded once and returned to the documents. He flipped to the section containing the easement filing and associated federal documentation. He read silently for several seconds. Then he paused, not abruptly, just long enough for the air to shift. He looked up from the page. Captain Callahan, he said. Yes, Your Honor. You are currently active duty United States Army. Yes, sir. Rank? Captain. He glanced back down at the document. Civil Affairs. Yes, Your Honor. He studied the service record summary included in the filing, standard disclosure information tied to federal litigation. He didn't comment immediately. Daniel remained still. Torre's posture straightened. The judge turned one more page. He looked at the ribbon listing, then back at me. Afghanistan deployment. 2014 to 2015. Yes, Your Honor. He removed his reading glasses and set them down on the bench. For a brief moment, he didn't speak. Then he leaned forward slightly. This court recognizes your service to this country, Captain. The words were calm, measured, not theatrical, but they carried through the room. It wasn't part of the ruling. It wasn't required by procedure. It was an acknowledgement, pure and simple. He stood. It wasn't dramatic. It wasn't rushed. It was deliberate. Ma'am, he said, voice steady, on behalf of this court, we acknowledge and salute your service. No one clapped. No one moved. The silence that followed wasn't confusion. It was recalibration, a shift in the room's gravitational center. Daniel's jaw tightened almost imperceptibly. Torai's hands folded in her lap, stilled completely. The judge sat back down. This court will now return to the matter at hand. He reopened the binder. Executor removal is not warranted absent statutory grounds. Comparative earnings and professional background do not constitute incapacity. The statute requires evidence of misconduct, conflict of interest, or inability to fulfill duties. The record shows none of these. He referenced the easement documentation. The conservation easement appears properly executed and recorded. Challenges to its validity would require substantive evidence beyond speculative economic projections. He looked directly at Daniel. Speculation regarding opportunity cost does not override a binding instrument. Daniel nodded stiffly. The judge continued reviewing briefly, then closed the binder. For purposes of today's hearing, the motion to remove the executor is denied. The gavel struck once, controlled, final. Court will proceed to schedule further review of any federal tax implications separately, if properly supported. But the executor remains in place. The easement remains binding. The room began to move again. Papers gathered, chairs shifted. The hearing had not turned into spectacle. It had not veered off into emotion. It had returned to structure. As the judge exited, the reporters in the back row exchanged quick notes. The land trust representative exhaled audibly. Across the aisle, Daniel began stacking his documents without looking up. Torai remained seated for a second longer than necessary. Then she stood. The hallway outside courtroom 4B felt narrower than it had an hour earlier. People moved around us, attorneys heading to other hearings, clerks carrying files, a reporter typing quickly into her phone. But the air between Torai and me stayed tight. Daniel adjusted his cufflinks as if the last 30 minutes had been a minor inconvenience. We'll review the order once it's docketed, he said evenly. Ms. Parker shook his hand. Of course. Professional, neutral, no raised voices. Federal court isn't a place for theatrics. Torai finally looked at me. For once, her eyes weren't scanning my sleeves. They didn't rule on the easement itself, she said. They ruled on the motion you filed. Her jaw tightened slightly. This isn't over. It wasn't a threat. It was a business statement. The kind of thing you say when you're regrouping, not surrendering. I nodded once. File what you need to file. Daniel stepped in smoothly. We'll consider our options. He spoke the way attorneys do, when they're recalculating in real time. The elevator doors opened, and we stepped inside together. No one spoke. The mirrored walls reflected 3 different versions of composure. On the ground floor, the doors slid open again. Torai walked ahead toward the exit without waiting. Outside, the Atlanta morning was brighter than it had been when we entered. Traffic steady. Reporters positioned casually near the courthouse steps. One of them approached Ms. Parker first. She handled it cleanly. The court denied the motion to remove the executor, she said. The estate remains under current administration. No commentary, no celebration. The reporter glanced at me. Captain, any statement? The will stands. That was enough. Across the steps, Torai paused near the curb where Daniel's car was waiting. She spoke quietly to him, then looked back once more. Not angry, not mocking, evaluating. I walked toward my own car, parked a block away. The uniform felt heavier now, not physically, but because it had just been measured in a civilian arena. Judges don't salute uniforms. Daniel had been right about that. The judge hadn't ruled in my favor because of my service. He had ruled because the statute required it. But the acknowledgement had shifted something. It reframed the narrative. Inside that courtroom, I wasn't a minimalist lifestyle. I wasn't limited exposure. I was a federal officer with documented compliance and a binding instrument in hand. That mattered. Back at the hotel, I packed my bag slowly, folded the uniform jacket carefully. The cuffs were still slightly worn. They would always be slightly worn. I thought about the decision I had made that morning when I buttoned it. I could have worn a civilian suit, a tailored navy blazer, something newer, something that might blend better into a room full of corporate attorneys. Instead, I chose the uniform, not for optics, for alignment. The Army doesn't allow you to selectively display your record. It's either worn correctly or not worn at all. Every ribbon, every badge, every insignia means something specific. You can't embellish. You can't inflate. You can only show what you've earned. Torai sees clothing as branding. I see it as identification. There's a difference. My phone buzzed. A notification from the court's electronic system. The written order had been docketed. Motion to remove executor, denied. Concise, clean. Ms. Parker sent a short follow-up message. Strong language in the order regarding statutory grounds. Good for record. Strong language. I opened the PDF. The judge had written that removal of an executor requires evidence of misconduct or incapacity, not comparative financial advantage. He emphasized that fiduciary duty centers on adherence to the decedent's expressed intent. Expressed intent. Dad's signature sat at the bottom of that easement. That was the intent. There was a brief knock on my hotel door. Ms. Parker stood outside holding a folder. "I figured you'd want this printed copy," she said. "Thank you." She stepped inside for a moment. "They'll regroup," she said matter-of-factly. "Daniel doesn't like losing motions." I noticed. He may try to frame the tax angle more aggressively next time, but today's ruling makes it harder. She paused. For what it's worth, wearing the uniform was the right call. I raised an eyebrow slightly. "Not because of sentiment," she clarified. "Because it's transparent. You didn't try to rebrand yourself for the room. You showed up as exactly what you are. That reads differently than someone trying to fit a mold." That was exactly it. Rebranding implies insecurity. I wasn't insecure about my record. I knew what I had done, what I had earned, what I was capable of. I didn't need to dress it up. After she left, I sat at the small desk and opened my laptop. I logged into the estate account and reviewed the compliance checklist again. Quarterly land trust report due in 60 days. Property tax documentation current. Boundary inspections scheduled for next month. Nothing had changed in those responsibilities. The federal motion was noise around the perimeter. The core work remained. I checked my unit email. Routine updates, training schedules, no escalation from the clearance office. Professional life intact. Torai's world operates on momentum. Deals move quickly. Delays cost money. My world operates on procedure. Slow, structured, documented. The friction between those worlds had finally surfaced in a courtroom, and the structure had held. I zipped my bag closed and carried it downstairs. At checkout, the clerk glanced at my uniform and smiled politely. "Have a good day, ma'am." "Thank you." Outside, the air had warmed. I loaded my bag into the trunk and paused for a moment before getting in. Torai had expected embarrassment. Daniel had expected an easy comparative argument. Neither happened. But neither had anything dramatic. No shouting, no collapse, just a denial order and a reminder that statutes matter more than style. As I started the engine, my phone buzzed again. A text from Torai. "Call me when you can." Short, direct. I stared at it for a second before setting the phone down on the passenger seat. The engine idled steadily. I pulled into traffic and headed north, merging into the flow without signaling anything beyond the standard turn. The traffic thinned as I crossed back into North Carolina, and I finally picked up the phone. "I figured you'd call," Torrey said. "I'm driving. I won't keep you long." There was no anger in her voice, just calculation. "You know this isn't finished," she said. "He can file whatever he wants." "You don't sound concerned." "I'm not." A short pause. "You embarrass me in there." I didn't say anything. That's the problem. I almost laughed at that. Silence has always bothered her more than criticism. "You made it look like I was attacking a war veteran," she continued. "You filed the motion. You wore the uniform. I wear it to court when I'm required to." "You weren't required." That part was true. Active duty officers can appear in civilian attire for personal legal matters. I chose not to. "I wasn't hiding it," I said. She exhaled through her nose. "Do you know what that judge standing did to the room? He acknowledged service. He shifted sympathy." Federal judges don't run on sympathy. They run on record. But perception matters in every arena, even federal ones. "That wasn't strategy," I said. "It may not have been yours," she replied. We both knew Daniel had miscalculated something. Not the law, the atmosphere. She ended the call without raising her voice. I drove the rest of the way back to Fort Liberty in steady silence. By the time I reached my apartment, it was early evening. The building looked the same as always. Brick exterior, modest parking lot, no iron gates, no fountain. I carried my bag upstairs and hung the uniform jacket carefully in the closet. The cuffs were still slightly worn. I changed into jeans and a plain t-shirt, then opened my laptop again. The court order had already circulated through a few local legal news feeds. Nothing dramatic, just a summary. U.S. District Court denies motion to remove executor in conservation easement dispute. 2 paragraphs. Down a brief mention. Judge Whitmore acknowledged the executor's active duty military service during proceedings. That was it. No headlines, no viral moment, just documentation. My phone buzzed again. This time, an email from Magnolia Resort's corporate office. Addressed to Torrey, copied to me as executor. Subject, development proposal status update. I opened it. They were requesting clarification on the estate's position following the court's denial. Polite language, business tone. Translation, are we still on track or not? Torrey had likely forwarded it intentionally. She wanted pressure visible. I drafted a short reply. Per federal court order, executor authority remains unchanged. The conservation easement is binding. Development proposals inconsistent with recorded restrictions cannot be considered. Direct, neutral, legally precise. I hit send. Minutes later, my phone rang again. This time it was Daniel. "I assume that response was yours," he said. "Yes. You understand the land trust agreement could still be reviewed for compliance with IRS valuation standards. If you believe it's defective, file a motion. You're very confident." "I'm consistent." He didn't respond immediately. "You're not maximizing value," he said finally. "I'm executing a will." "You're hiding behind it." "I'm enforcing it." A slight shift in his tone. "You think the judge standing today settles the perception issue?" "I don't care about perception." "That's naive." "Maybe." He let out a controlled breath. "There's still an opportunity to negotiate," he said. "Partial development, structured carve-outs, something that respects the easement but unlocks value." "That's not what the document says." "You're inflexible." "Yes." Silence again. "You're going to cost your sister a significant opportunity," he added. She made the offer before the estate closed. She anticipated resolution. She assumed control. He didn't argue that point. After we hung up, I leaned back in the chair and stared at the ceiling for a moment. In Torrey's world, persistence is strength. If the door doesn't open, you find another angle. You negotiate. You pivot. You keep moving until something gives. In mine, if the order is clear, you follow it. You don't reinterpret. You don't renegotiate. You hold the line. There's comfort in that clarity. Later that evening, I drove to the base gym and ran 5 miles on the treadmill. Not out of stress, out of routine. Discipline doesn't adjust itself to civilian litigation. When I got home, there was a new message waiting from the land trust. Appreciate your continued compliance with easement terms. Please confirm boundary inspection date next month. No drama there either, just follow through. I confirmed the inspection date. Then I opened the estate account ledger and reviewed transactions again. Every payment documented, every expense categorized. If Daniel came back with a tax valuation argument, he would need numbers, solid ones. The appraisal filed with the IRS had been conducted by a certified appraiser with conservation expertise. It included comparable sales and discounted value for development restrictions. It wasn't sloppy. That's what frustrated them most. The paperwork was tight. Torai's strategy relied on flexibility, reinterpretation, market shifts. Dad's strategy relied on permanence, perpetual. That word in the easement mattered more than any projected revenue. I closed the laptop and checked my phone one last time before setting it on the nightstand. No new filings, no emergency motions, just quiet. The kind of quiet Torai once called avoidance. I turned off the light and let the room settle. The land remained untouched. The order remained entered. And somewhere in Atlanta, I knew Torai was already recalculating. 3 days later, the written order hit the public docket in full. Not a summary, the complete text. Daniel called first. "You've probably read it by now," he said. "I have." The judge's language was precise. He didn't just deny the motion, he clarified it. Removal of an executor requires evidence of misconduct, incapacity, or clear breach of fiduciary duty. Comparative financial status is not a statutory standard. That sentence alone closed a door Daniel had hoped to keep cracked. He also added something else. The court declines to reinterpret a duly recorded conservation easement absent compelling evidence of procedural defect. Procedural defect, that was the only remaining path. "You understand this doesn't prevent further review," Daniel said. "I understand it sets the standard." He exhaled slowly. "You've made this harder than it needed to be." I didn't file the motion. He didn't argue that. After the call ended, I received an email from the land trust attorney. "Strong order. Judge emphasized binding intent. That helps." That helps. In development disputes, clarity is leverage. Later that afternoon, Torai showed up at my apartment. No text, no warning. I opened the door, surprised but not startled. She wasn't dressed for a meeting. No blazer, no heels, just jeans and a loose sweater. It made her look younger, less armored. "Can I come in?" she asked. I stepped aside. She walked in slowly, glancing around at the small living room. Couch, coffee table, bookshelf with a few framed photos from deployment ceremonies and family gatherings. Nothing expensive, nothing staged. "This is where you live," she said. "Yes." She nodded once like she was confirming something for herself. "I read the order," she said. "So did I." She sat down on the edge of the couch. "I didn't expect him to stand," she admitted. "It wasn't part of the ruling." "No," she said quietly, "it wasn't." She looked at the bookshelf, at the framed photo of Dad in his marine dress blues. "You know what bothered me most?" she asked. I waited. "He didn't stand because you're my sister," she said. "He stood because of you." There was no sarcasm in her voice. "He acknowledged service," I replied. He shifted the room. I didn't argue. Perception matters, even if it doesn't decide motions. She leaned back slightly. "I built my entire career on projecting competence," she said, "walking into rooms where people underestimate you and proving them wrong." "I know." "And then you walk into federal court looking like you don't care about appearances." I care about accuracy. She let out a small breath that could have been a laugh. You've always done that. You refuse to play the game. I play the rules. She shook her head slightly. You think those are the same thing. In federal court, they are. Silence settled between us. Not hostile, not warm, just unfiltered. You could have taken the money, she said. I know. 75,000 isn't nothing. It wasn't the amount. She glanced at the bookshelf again. You really think Dad cared more about trees than financial security? He cared about permanence. She looked at me carefully. You never asked him to reconsider. He wasn't unsure. He was old. He was deliberate. That word again, deliberate. She leaned forward, elbows on her knees. You don't understand what it's like to carry investor expectations, she said. To promise returns, to build something and then watch it stall. I understand obligations, I said. They just look different. She studied my face for a moment. You're not angry. No. You're not gloating. No. That's infuriating. I almost smiled. That's consistent. She stood up and walked toward the bookshelf. Her fingers traced the edge of the frame holding Dad's marine photo. He would have liked the way that Judge handled it, she said quietly. He would have liked the order. She nodded slowly. You know what Daniel said after? She asked. What? He said you weaponized the uniform. I didn't. I know. That was new. For the first time, she wasn't questioning my motives. She was acknowledging them. You really believe you're protecting something bigger than profit, she said. Yes. And you're willing to absorb the fallout. If there is fallout. She turned to face me fully. There will be, she said. Magnolia isn't going to walk away quietly. Then they'll need a procedural defect. She held my gaze for a second longer than usual. You're not going to bend. No. She nodded once. Then I need to decide if I keep pushing. That's your choice. She looked around the apartment again, not judging, observing. You don't live like someone who needs to win, she said. I live like someone who needs to sleep. That earned the smallest hint of a smile. She walked toward the door. I underestimated you, she said. That's not new. She paused at the threshold. You think this is about the land, she said. It's not. What is it about? She hesitated, just long enough to make the question real. It's about control, she said finally. I didn't respond immediately. Control looks different depending on your world. For her, control meant directing outcomes, making things happen, bending circumstances to your will. For me, it meant maintaining integrity within boundaries, holding the line when pressure tried to move you. She opened the door. I'm not promising anything, she said, but I'm not filing anything today. That's noted. She stepped out into the hallway. I closed the door quietly behind her. The apartment felt smaller after she left, but not suffocating, just quiet. On the table, my phone buzzed with a new notification from the court's electronic system. No new filings, just routine docket updates. I set the phone down and walked to the window. Outside the parking lot, lights flickered on as the sun dipped lower. The land in North Georgia was still untouched. The easement was still binding. And for the first time since Dad's will was read aloud, the argument wasn't about money in that moment. It was about who gets to define value. The next week, the boundary inspection took place under a clear Georgia sky. I met the land trust representative at the gravel entrance just after 9:00 a.m. clipboard. Survey map, practical shoes, no media, no lawyers, just procedure. We walked the perimeter, markers checked. Signage confirmed. No clearing had taken place along the creek line. Everything matched the recorded easement conditions. Looks good, he said. No violations. That's the goal. He smiled faintly. You'd be surprised how often that's not the case. I wouldn't be. People test limits when money is involved. After he left, I stayed on the property a while longer. The air was still, leaves shifting lightly overhead. No construction equipment. No survey flags marking future foundations. 200 acres exactly as Dad intended. My phone rang around noon. It was Daniel. "We've advised Magnolia to suspend further action," he said, "based on cost-benefit analysis." That sounded like him. "They're not pursuing additional filings." Not at this time. Not at this time. It wasn't surrender. It was recalibration. "You made your point," he added. I followed the document. "Yes," he said quietly, "you did." He ended the call without argument. I stood there for a moment, letting that settle. This wasn't a dramatic collapse of a corporate empire. No public scandal. No courtroom fireworks beyond what had already happened. Just a strategic withdrawal. Later that afternoon, Tori called. "I told Magnolia we were done," she said. "For this property." "For now?" I asked. "For this property." That distinction mattered. She sounded tired, but not defeated. "They weren't happy," she admitted, "but they understand risk. Risk exists." She exhaled softly. "You really weren't going to bend." "No." "I know." We let that sit between us. "I've been thinking about something," she said. "That's usually productive." She ignored the dry tone. "I built my reputation on turning land into profit," she continued. "It's what I do. When I saw that acreage, I saw potential, and Dad saw protection." "Yes." A pause. "I thought you were being stubborn," she said. "Rigid, emotional." "I was being compliant." She laughed quietly at that. "Only you would frame it that way." "It's accurate." She shifted her tone slightly. "When the judge stood," she said, "it wasn't about sympathy, it was about record." "Yes." "And I've been misreading you for years." "That's possible." "I thought your silence meant you didn't care." "It means I don't escalate." Another pause. "You didn't try to humiliate me," she said. "You could have." "I didn't need to." "That's what makes it worse." I didn't respond. She continued. "I went back and reread Dad's letter attached to the will." The letter had been short, 2 pages, clear. "He wrote that the land was the one thing he never wanted leveraged," she said. "He underlined leveraged." "Yes." "I used that word in my proposal." "I noticed." Silence again. "I'm not apologizing for being ambitious," she said finally. "I wouldn't expect you to, but I am acknowledging that I pushed this too far." "That's your call." She took a breath. "I'm going to step back from the estate filings," she said. "No more motions, no more challenges." That was more definitive than Daniel's phrasing. "Understood," I replied. "I still disagree with you," she added. "That's allowed." "But I'm not going to litigate it." That was the real shift, not agreement, acceptance. We hung up without ceremony. That evening, I drove back to North Carolina and stopped at a small hardware store near base. I bought a weather-resistant plaque and had it engraved. Nothing elaborate, just CLLHAN Conservation Land. Protected in perpetuity. The next weekend, I drove back to the property and mounted the plaque near the original wooden sign Dad had carved years ago. No ribbon cutting, no announcement, just a visible marker that the decision was settled. At my next unit briefing, nothing had changed. Training schedules, deployment rotations, budget discussions, professional life moved forward. No one at work treated me differently because a judge had stood in a courtroom. That wasn't how the Army works. Respect is documented long before it's acknowledged publicly. A week later, a small article ran in a local Atlanta business journal. Federal court upholds conservation easement in Callahan estate dispute. 2 paragraphs about development halted. 1 sentence about military service acknowledged during proceedings. That was it. No viral headlines, no trending clips, just record. Tori sent me the link without commentary. I replied with a simple, "Noted." We met once more at the property about a month later. No lawyers, no investors. She walked the creek line quietly. It's quieter than I remember, she said. It hasn't changed. That's the point, isn't it? Yes. She looked at the plaque near the entrance. You actually engraved something. I prefer clarity. She shook her head with a faint smile. You win. This wasn't about winning. It feels like it. It's about enforcement. She studied the trees for a long moment. You really don't care about the money. I care about the document. She laughed lightly. That might be the most frustrating thing about you. I've been told. As the sun dipped lower, casting long shadows across the clearing, she turned toward her car. You know, she said, if Dad were here, he'd probably say we're both stubborn. He'd be right. She nodded once. I'm not going to pretend I agree with everything you do, she said, but I respect that you don't bend. That's enough. She drove away without another word. I stayed behind for a few minutes longer, listening to the wind move through the trees. No construction noise, no survey stakes, no negotiation. Just land preserved exactly as written. Family revenge stories usually end with someone destroyed. This one ended with something intact. The land stayed protected. The easement stayed binding. And the uniform hanging in my closet back in North Carolina still fit exactly the same way it did before anyone laughed at it. The truth is, nothing about that courtroom changed who I was. My sister laughed at my worn-out suit because she saw fabric. The judge stood because he saw record. Neither moment defined me. The paperwork did. The signature on that easement did. The choice to follow it through did. Family drama has a way of turning everything into pride and ego. But most family revenge stories aren't about destroying someone. They're about standing still when pressure tries to move you. In federal court, money talks loudly. Discipline doesn't, it just stays consistent. I didn't protect that land to prove a point. I protected it because it was written down, signed, and meant to last. And sometimes the strongest move in any family revenge story isn't winning an argument. It's refusing to rewrite what was already clear. If this story meant something to you, if you've ever been underestimated, judged by appearances, or pressured by your own family to abandon your principles, subscribe to the channel. We tell real military and family revenge stories that focus on discipline, accountability, and quiet strength. There's a difference between loud success and earned respect. If that difference matters to you, you're in the right place. If this story gave you chills, smash that like button and tell us in the comments. What's the most satisfying revenge you've ever witnessed? And of course, subscribe for more stories like this.